I am for the appellants. I am in mat number 1615, serial number 82 in your lordship's daily causes.
You are a mat
1615, lordship. 1615, 1615 of 2023. Saurabh Boshak and others. Lordship, I must admit at the very outset, your lordships have been very kind and exceptionally patient.
This compliment will remain after we deliver the judgment.
I was in two minds whether I should. As your lordship has shown, is a matter of fact. In fact, I did not want to
come to your case. Yes.
May I just say one thing, because your lordship said it. When I started my profession, Mr. Lordship, in 1615, there are 334 appellants. They're all from the district of Jalpaiguri.
They were appointed and thereafter completed training.
Yes, Lordship. The appointments of all the 32,000 were over by April 2017.
Yes.
These individuals were appointed post all the trained candidates were appointed.
So this 32,000, this cancellation includes untrained.
Yes, that was
the untrained.
Yes, because the impugned order
yes
makes a specific reference saying that in fact, let me just get to that.
Yes, paragraph 7. Yes.
It says the trained are exempted. Yes.
So, trained are?
The trained were not part of that order. That's about it. Yes.
No, we are asking this 32,000 is trained, untrained persons participated and got the training.
Absolutely. And they were trained by 31st of March 2019.
Training was over by 31st of
2019. Because I'll just reiterate just 2 points. Lordship has heard it. After the directive principles on education was called out by Supreme Court and said right to education is a fundamental right, the central legislature came out with the Right of Children to Free and Compulsory Education Act 2009.
Yes, we need not go.
Yes, and so once NCT gave the guidelines, then TET started. So therefore, and these are untrained at the time of induction, trained by 2019. Now, much has been said about the interview and the aptitude process. There are two things I need to point out, very specific to this case. In this 334 appellants from Jalpaiguri district, now what has come to our notice on perusal of the record, that in the impugned order, what it does not have anybody, no interviewer, no candidate, and none of the 139 petitioners are from the Jalpaiguri district.
No Jalpaiguri person amongst the 4 petitioners who were examined.
The petitioners.
Jalpaiguri district.
Yes, and there are few other districts in the state in which the similar situation is there. No petitioner, no candidate interviewed, no interviewer asked question by the state. And to give a quietus to that issue, Lordship, my senior Mr. Shagor Bandyopadhyay, when he had appeared, he had handed out this one notification, one memo, a notice from the board. I'll just reiterate only one point in this, Lordship. This is dated 5/12/2016. Lordship may go overlive. This is a notice to the districts. Lordship may turn over to the second page. I'll forward.
Yes.
The chairman copy forwarded for information to the chairman interview board and DI of schools of the 4 districts, namely Cooch Behar, Howrah, Purbo Mednipur, Bardhaman, for making arrangements for smooth conduct of viva voce / interview and aptitude test and scrutiny verification. Now, Lordship, I just stop here. For making arrangements for smooth conduct of viva voce / interview and aptitude test.
Yes.
The point I'm trying to highlight, Lordship, the board goes on record, sends notice, and informs them for the purpose to the DPSC for purpose of conducting interview and aptitude test.
Yes.
That's the best documentary evidence as a candidate that I can lay my hands on to prove that point. Lordship, I'll have just 2 basic legal issues, though this looks very heavy. I will just Lordship in this compilations, his handing over. It has been a tough job on my part to ensure that no repetition takes place. Lordship may come to the judgment in serial number 4, 2009 8 SAC 106. 2009 8 SAC 106. It's a famous case of R.K. Anand versus Registrar, Delhi High Court.
Yes.
Lordship may kindly come to page 120.
Which paragraph?
Para 292.
You will be relying on paras?
292, 293, 328. Then 329, 332. May I start?
Show us the relevant paragraph.
Yes, Lordship. Lordship may kindly come to the page 120 of the compilation. That is internal page number 198.
We are there. Yes.
Yes, Lordship, paragraph 292.
Yes.
The submission of Mr. N. Rao are based on 2 premises. One, the sting of program telecast by NDTV was of the genre trial by media. So that's my point, Lordship. Trial by media. And 2, the program interfered or tended to interfere with or obstructed or tended to obstruct the proceedings of the BMW trial that was going on at the time of the telecast. If the 2 premises are correct, then the rest of the submissions would logically follow. But are the 2 premises correct? Now, Lordship comes to the para 293 when the court questions what is trial by media. What is trial by media? The expression trial by media is defined to mean the impact of television and newspaper coverage on a person's reputation by creating a widespread perception of guilt, regardless of any verdict in a court of law. During high publicity cases, the media are often accused of provoking an atmosphere of public hysteria, akin to a lynch mob. Akin to a lynch mob, which not only makes a fair trial nearly impossible, but means that regardless of the result of the trial, in public perception, the accused is already held guilty and would not be able to live the rest of the life without intense public scrutiny. I pause for a while, Lordship.
Yes.
In this case, Lordship, with all humility, as I try to understand the rationale behind the impugned order, I'm not passing any judgment on human being. I'm not passing any judgment on any individuals. I'm just trying to assess the judgment within the parameters. Now, what happens is, in this case, Lordship, the 32,000.
Yes.
The 32,000, Lordship, with absolute humility, if I may say, that in the investigation by the Central Investigative Authorities, CBI and the ED.
All right, we understand you.
No, my point is not a single one has been accused. Yes. Now, Lordship may kindly come to page para 328, 329. That is 328 is at page 126 of the compilation, Lordship. We also find that, like almost every other sphere of human activity in the country, the electronic para 328, we also find that like almost every other sphere of human activity in the country, the electronic news media has a very broad spectrum ranging from very good to unspeakably bad. The better news channel in the country, NDTV being one of them, are second to none in the world in matters of coverage of news, impartiality and objectivity in reporting, reach to the audience and capacity to influence public opinion, and are actually better than many foreign TV channels. But that is not to say that they are totally free from biases and prejudices, or they do not commit mistakes or gaffes, or they sometimes do not tend to trivialize highly serious issues, or that there is nothing wanting in their social content and orientation, or that they maintain the same standards in all their programs. In the quest of excellence, they have still a long way to go. And the next paragraph is what I'm a little perturbed with, and it reflects what happens. A private TV channel, which is also a vast business venture, has the inherent dilemma to reconcile its business interests with the higher standards of professionalism demands of profession. The two may not always converge, and then the TV channels would find its professional options getting limited as a result of conflict of priorities. The media trips mostly on TRPs, television rating points, when commercial considerations assume dominance over higher standards of professionalism.
Yes.
Page.
Okay. Anything else?
Yeah, in this, just one more paragraph, Lordship. I'll just read page 127 in the compilation, page paragraph 332.
Yes.
I'll just read the first sentence and leave it at that. No personal expression, but this is something which perhaps Supreme Court also said, don't do it. We have viewed with disbelief senior advocates freely taking part in TV debates or giving interviews, or a TV reporter, anchor of the show on issues that are directly the subject matter of cases pending before the court, and in which they are appearing for one side or taking up briefs for one of these sides soon after the TV show. Such conduct reminds us of.
But there is no such allegation here.
No, I'm not. I'm just saying what in the parameters of trial by media. Lordship may kindly come to the first judgment in my compilation. First judgment in my compilation, 2023, page 1, Lordship, of the compilation.
Yes.
2023, 9 ACC.
Paragraphs?
Yes. I'll just paragraph 6, page 186.
Para 6.
Para 6, Lordship. 186, para 6. I'll skip para 6, Lordship. I'll read it out. Media reporting on matters involving commission of crime.
Relevant.
Lordship may kindly come to paragraph 7.
Yes.
Paragraph 7, it starts at page 120. If your Lordship may kindly come to the next page, page number 4. In a matter which implicates the culpability of the person who is under investigation. I'm cutting it short. Media reportage in a manner which implicates the culpability of the person who is under investigation is liable to seriously impinge upon the reputation and personal dignity of the individual under investigation. Biased reporting also gives rise to public suspicion that the person under investigation has committed the offense, though the complicity of the accused is yet to be investigated. And
paragraph?
Para 7, Lordship. My apologies. Para 7 starts at page 3.
Yes, yes.
The last 2 words in that page is media reportage. Lordship may kindly come to page 4 of the compilation. Media reportage in a manner which implicates the culpability of the person who is under investigation is liable to seriously impinge upon the reputation and personal dignity of the individual under investigation. Biased reporting also gives rise to public suspicion that the person under investigation has committed the offense, though the complicity of the accused is yet to be investigated.
Yes.
And in charge sheet is submitted. Lordship may kindly come directly to the last paragraph that I would like to, paragraph 19 in internal page 7, compilation page 7.
Yes.
This is what the Supreme Court, this is 3-judge bench. It deals it like a PIL. It says it is equally important to emphasize the nature of disclosure which is made by the police in the course of media briefing should be objective in nature and should not consist of a subjective opinion prejudging the guilt of the accused. The guidelines must duly factor in. This is what I'm insisting on, Lordship. The guidelines must duly factor in the need to ensure that the disclosure does not result in a media trial so as to allow for prejudging of the guilt of the accused. Most important, Lordship, what I'm saying now, media trials are liable to result in a derailment of justice by impacting upon the evidence which would be adduced and its assessment by the adjudicating authorities. So the Supreme Court in this judgment recognizes the ill effects of prejudging an issue by the media.
Yes.
Lordship, I would now go to my next point. Lordship may kindly come straight to the judgment in serial number 7 of my compilation. Well, it's 2025 SCC Online, Supreme Court 179. 2025 SCC Online, Supreme Court 179. Lordship may kindly come to page 160 of the compilation.
It was the paragraph.
Yes, Lordship, I will. The paragraphs that I would be relying upon is 3, 13, 16, and 68, importantly. 3,
yes,
13. Now, this is a case, the point that I'm...
Yes.
Yes, Lordship, may just permit me just a minute to just go to my compilation. Yes. In paragraph 3, Lordship, in the middle, therefore in the case, Lordship has that. Therefore in the case, we are confronted with a conflict between the two foundational principles of natural justice. That is, rule against bias, nemo judex in causa sua, and the right to a fair hearing, audi altrum partem.
Yes.
Yes. Lordship,
This is
Just to-
restricted
just to-
on the principles of natural justice. This
I will-
does not give anything new concept.
I understand. There are two parts to it. One is you give a right to hearing and bias. So therefore, the issues are, Lordship, at paragraph number 13,
Yes.
page 163. Whether the selection is vitiated for violation of the first claim of natural justice, rule against, and that is rule against bias. Lordship has that? Yes. The pattern, issue B, I'll go straight to the conclusion after the issues. Where it is a case of violation of principles of audi alteram partem, is demonstration of prejudice necessary to succeed with the claim of violation of principles of audi alteram partem? And C, whether the breach of principles of audi alteram partem at the original stage can be cured. Very important, Lordship. At 164, issue number C, whether breach of principles of audi alteram partem at the original stage can be cured at the revisional stage. Lordship may now come to the conclusion. Paragraph number 68, Lordship.
This settled proposition, it cannot be cured.
Yes, that's about it. And it says so.
Settled proposition. Yes. Thank you, Mr. Majumdar. Yes, anybody else?
Lordship, may I just take half a moment?
Yes.
There's a Delhi High Court judge.
Another judgment you want to?
No. I just want to say something. On a lighter side, I'll just take half a minute. In his retiral speech, Lordship, he said something very important. He said, when a petitioner comes to the court on a trial, the petitioner knows what is right, what is wrong, the facts. The respondent knows what's the fact. If anything is on trial, is the judges. So, Lordship, as I leave you with the onerous task, I am most deeply grateful and obliged.
Thank you. Yes. Yes, Mr. Banerjee.
The last